Mr. Miller. Good afternoon.
Give you an easy last name, Judge.
Oh, good. I got that one right, too. Wow.
Pierre Miller. I have the honor of representing the appellant, AKD Investments, LLC. I think, fortunately, in this case, there's a lot that the parties do agree on, that there aren't, that they're not, that the points of contention are fairly focused. We do agree with the standards or what the law is on the law of the case doctrine. Same issues that have been decided in the case, that decision will control in later stages of the case. And I think that we agree that the court did not, the bankruptcy court did not decide the same issue that is brought by the instant adversary proceeding, which is primarily what is the correct amount, what was the correct amount that was owed to Magazine. That was never decided previously to the bankruptcy court. It has never been decided at all in the bankruptcy court. That's what the subject of the adversary proceeding is.
Didn't the refinance order specify a defined amount?
It did not define the amount that was owed to Magazine. What it defined was the amount that AKD could pay out of the loan and the refinancing to Magazine, and that's a critical difference. In this case, the thrust of the case is to sue for recovery of a payment of amount not owed. And I think it's...
Let me ask a follow-up on that, is that before the bankruptcy, there was a motion where you disputed the amount owed, but in the amended motion, which was referenced in the refinance order, and tell me if I'm saying this incorrectly, but in that one, the dispute about the payment, how much was owed, was dropped.
I don't believe that's true, Judge. The amount that was owed was always under dispute. How that was going to be resolved was what was the difference between the first two motions. In the first motion, the request was made for the funds to be placed in escrow before they were handed over to Magazine so that the amount that was truly owed to Magazine could be determined before payment would be made. Magazine made the objection that their claim was going to continue to accrue, $4,000 a day in interest. And if the only deposit into the escrow was what they were claiming that day, and they prevailed, then they wouldn't have a way to recover the extra $4,000 a day plus additional attorney's fees that would have accrued after that deposit into the escrow account. So I think that their objection did have some merit there. So AKD then, in order to respond to that, said, okay, we're not going to handle the amount now. We will handle the amount after payment in a case to recover it later on. And that's why the second motion said we are asking for authority to pay the amount that they are claiming without prejudice. And the without prejudice language was not in the first motion because it didn't need to be. It was going to be held in escrow. But it was in the second motion, and that's where the dispute was preserved in that payment. I think that in order to handle this case, or to examine this case, it might be very helpful to look at what is the role of the bankruptcy court in this case, because this could have been handled extrajudiciously if AKD had never filed for bankruptcy. If they were under a threat of foreclosure and could borrow money from a rich uncle or whatever and pay it off, on the eve of foreclosure, they had a rich uncle agree to pay the money. They could have gone and paid the money under protest or without prejudice the day of the sale or any time before the sale and gotten the sale canceled and saved their property. And they would have had the right under Louisiana Civil Code Article 2299 to then sue for the amount paid that was in excess of what they owed, because they had said we're paying this without prejudice, same way people pay taxes under protest. The bankruptcy court, though, has a role of administering the bankruptcy estate for the benefit of all the creditors. And so AKD couldn't just get the money. They had a commitment. They had a source of funds. They couldn't just go and pay the money on their own. They needed to get the approval of the bankruptcy court because the refinance, the source of the funds was going to involve use of estate assets. And that's what the court decided. The court never decided, and it was never raised, and it didn't need to be decided at all, whether all of the amount that was paid was owed. All they needed to know was there going to be enough paid that the court could order that Magazine's release of its mortgage would be accomplished, and that new liens would be placed on the property in order to secure the loan from Jim Hughey, which was the source of the new
How
fund.
does the court read the fact that in the refinancing order, there is a fixed amount, but then later, which distinguishes those liens, the original liens, those get paid off. Then the question, though, is how do we read that then with the without prejudice language?
It's in there. It's in ordering paragraph number 6.
So I understand that, but how do we read those together? There's a defined amount where that loan is paid, and then how do we read that with the later language that says is without prejudice, without conditions?
I'm not sure that I understand the question, without prejudice.
Aren't they in tension with each other? Those
Sorry?
clauses, aren't those clauses in tension with each other?
I don't
Make the thing ambiguous?
believe so. The words without prejudice have a specific meaning.
Well, but so do the other provisions in the order. And the problem, I guess, you've got is the bankruptcy court later on down the road, when this was litigated, came back and said, no, it's been decided. The amount to be paid Magazine to cut them out of the transaction, so to speak, was the amount, and it's decided. So how do you get around that? In other words, isn't this a classic ambiguity?
I don't believe it is at all, Judge. As I said, the words without prejudice have a specific meaning that
Well,
it's
but
not.
it says without prejudice and without conditions. Aren't those two phrases in tension with each other?
I don't really know why the court added the bankruptcy court. I don't know whether it matters, but there are 2 different bankruptcy judges. Judge Magner was the original judge, and she was replaced by Judge Grable. But
Well, we have one order.
it's the same court.
This was entered by the one court and the one judge, and then you have a later order saying, no, this was decided because the number is in there, what you're going to pay out for Magazine.
And I think that the court was not. The court should have known that the bankruptcy order that was issued authorizing the payment authorized a limited amount of things because they had a limited role. Their role was to authorize AKD to borrow money from Jim Hughey. They authorized the AKD to take that money and make payments, a specific amount of which would be paid to Magazine. And then when that amount was paid, to order that the clerk of court would release Magazine's releases and releases of other unrelated parties, but would order the releases. And then the court ordered that Magazine could securitize its loan from Jim Hughey using that same asset that the court had now released. Couldn't order a release without paying that off. Ordered that amount, authorized that amount to be paid, and then authorized AKD to then enter into security agreements to securitize the loan that was the source of this repayment. And that's all the judge did. Without prejudice meant that there was a reservation of a cause of action to recover amounts that were paid that they didn't owe.
Oh, but I go back to what I said earlier. Isn't this a classic ambiguity? You say that's what it means. And the other side, Magazine, says, no, that's not what it means. What it means, I mean, it being the order in toto, I guess, is that there was a definite amount certain to pay Magazine off. That was how Magazine valued the debt that was outstanding, sort of the payoff amount, standard paying off one loan, taking out another, and replacing it. I mean, so isn't that an ambiguity? And if it's an ambiguity, the $64,000 question, I guess, is, don't we defer to what the bankruptcy court said in interpreting its own order?
I do not believe that it is an ambiguity, Judge. I think that it's clear that it was authorizing that there was a payment amount that Magazine had said. In fact, Magazine wouldn't even release the information about how much it was claiming that it was owed, and Judge Magner had to order Magazine to tell us how much the payoff was. And then this order clearly and unambiguously authorized AKD to pay off the full amount that Magazine claimed without any discussion whatsoever as to whether that was the amount that was owed. And the court was on notice that that AKD did dispute that because it filed 2 motions that brought that before the court. The first one saying hold the funds in escrow until this can be determined.
The second motion, as the district court said, didn't say that, and that's what was granted.
And the district court ignored the language that was in the motion and in the order itself. The district court here, anyway, meaning Judge African, not the bankruptcy court, but it cited the language saying you're authorized to pay this amount and then left out the part about you're not authorized to pay this amount without prejudice. In reading that language...
But what the district court concluded was, despite this without prejudice, whether that's a stray clause or whether that's an ambiguous clause, that the amount to be paid to Magazine was decided, and the bankruptcy court, when it concluded that it was decided, was correct.
I guess that's one way of interpreting it, but I don't think that the court, that's where their error was. Their error was in reading out language that has a purpose. And the court erred in saying, we don't care what this says, or I'm going to ignore this, or I'm saying that this doesn't create, or doesn't have the effect that you're claiming it does, and it clearly has to have some effect, or it wouldn't have been in there. To read it out is an error. And
Well, you don't read it out by finding it ambiguous. You then go to various modes of statutory construction or contract construction to try to figure out what the ambiguity means.
I understand your question a little bit better maybe now.
And the bankruptcy court came in and said, well, what it means is we decided the amount that was due Magazine.
I guess maybe the better answer would be that by deciding that it was ambiguous, that's where the court made its error. It still read it out by doing that, but it's not unambiguous. Louisiana Revised Statute 10-1308 says, a party that with the explicit reservation of rights performs or promises performance or assents to performance in a manner demanded by the other party, which was Magazine demanded, this is how much you need to pay. When they pay that amount with an explicit reservation, then their rights are preserved. And the statute says, such words as without prejudice, under protest, are the like, are sufficient. This is a place that I wanted to mention that we disagree with Magazine. Magazine has a couple of cases cited in their briefs that says that the reservation needs to be specific. And it does not. This statute covers that, and it says this is all you need, without prejudice. The case
What do we make of without prejudice and without condition?
I think it's just more the same. That Judge Magner intended that to be without prejudice, without conditions, you have your rights. That it's additional language that means the same thing and doesn't add or subtract anything to without prejudice.
If we assume there is an ambiguity, I know you disagree with that, but if we assume and we find there is an ambiguity, do you agree then that we give deference to the bankruptcy court?
Well, I suppose that I'm not sure how to answer that question, to be direct, but your job is admittedly to interpret this judgment. And so I suggest that would be error for this court to find an ambiguity where there is none.
That wasn't my question.
But if you do find an ambiguity, would you rely on the district court to do it? I'm not sure how else you would resolve that ambiguity. I would suggest that the case laws and the business and everything else that has gone on in interpreting this phrase has consistently interpreted this phrase as being preserving rights. In all the cases where there's a dismissal without prejudice, that means that all rights are reserved. All the cases that we've cited say it's all reserved. The statute says it's all reserved. There's nothing more required than to say without prejudice, and parties can sue again. We cited a case where in Dunster Live, the Fifth Circuit was faced with the issue of the plaintiff had brought a trade secret case. They failed to get an injunction stopping the defendants. They asked the court to dismiss the case without prejudice, and then the defendants came in and said, and when that judgment was granted, the defendants then came in and said, we're entitled to attorney's fees as the prevailing party. And the court said, you didn't prevail. Without prejudice means you didn't win, that this case is still going on and the parties can still proceed, that their rights, they have not lost their rights.
Counsel, help me with the time lapse here. This order is entered in, 2015, February of 2015? Why did it take 5 years for your client to pursue these?
Just kind of the realities of life, Judge.
Realities of life. I mean,
Yeah,
if it was reserved and if there were any question, why wouldn't they have proceeded immediately?
There was the next thing that was done was proceeding with the bankruptcy plan, the plan of administration, the plan of reorganization. And
Was the plan noticed to Magazine?
It was. They were electronically.
The bankruptcy court says it's not, correct?
The bankruptcy court did not examine the record to see that. They made a mistake. It's clear in the record that that Magazine, through its counsel, received the standard electronic service of those pleadings. Every single, and there were multiple of them. There was amendments to them, and they received them all. The bankruptcy court simply failed. That's another place where the bankruptcy court erred. As far as the ambiguity in the language, I'd also point to the definition that we used to blacks. Blacks isn't unambiguous. It says that without prejudice means that the parties still have their rights, and that a payment of a thing, the payment doesn't, if it's made without prejudice, then the payment means you still have your rights to say that they were wrong and they didn't owe this. I think that that those words have been used for so long and have developed so much case law that they are not ambiguous, and that it's an error to find that they are ambiguous.
Do we look at the words without prejudice in isolation, or do we look at the context of the broader order in determining whether there's an ambiguity?
I think first you look to the terms of where they are in the order, and then next you can look to context as far as where they were in the case and how they came to be in there. There was a second motion filed that added that asked for those words to be added. I see that I'm at the end of my time.
You have time for rebuttal. Thank you, counsel. Mr. Marsiglia.
Thank you, Your Honor. Michael Marsiglia on behalf of Magazine Investments 1, LLC.
Can you start, what does without prejudice and without conditions mean in this context?
In this context, without prejudice and without conditions means that has been the issue, obviously, in this case. And I draw the attention to the appellants. They have not presented any cases whatsoever that demonstrate that their situation has happened anywhere. The one case that they cite is a case out of the New York bankruptcy district that talks about without prejudice language being included into an order that dealt with, I would argue, a similar situation, the selling of assets in the bankruptcy proceeding. It's
But what do you say it means?
without prejudice.
In the context of this order.
The without prejudice means it's reserving rights to issues that have not been resolved. In this case,
How does that not apply in this clause to exactly why we're here, which is the overage that they say they overpaid Magazine, or the excess fees and charges?
well, and that's, I think, where the bankruptcy court order granting summary judgment and the district court order affirming that judgment states that the issue of the amount owed, the correctness of the amount owed, was decided.
But what does without prejudice and without conditions mean? That was Judge Mazzant's question also. What does it mean? It's there.
It means that it's reserved, like, as without prejudice means it's reserving the rights of both the creditors and of the
What are those rights?
I'm not entirely sure what rights. It's rights that they
Well, what
may
would
have
those rights-
outside of what's already been decided.
What would those rights be other than what this dispute was that engendered the entry of this order in 2015?
I'm not sure what other rights they would.
The initial motion they filed spelled it all out. It was that they were paying Magazine too much, and Magazine wouldn't substantiate what was owed. And so then they filed this amended order, and then amended motion, and then this order is sort of the end result of that. So again, what is without prejudice and without conditions preserving if it's not AKD's claims?
And I don't know necessarily what it's preserving for AKD specifically, but what the courts have said is that it's not preserving to challenge the correctness of the amount, because that was already decided at the bankruptcy.
We're kind of going in circles.
We are.
I think one thing you might say is that you don't know what it means because it was put in there in its intention with other clauses in the order. And so what it creates is some kind of ambiguity about what was actually done. I mean, that's the way I read this.
I believe that's a fair interpretation, Your Honor. And as Judge Wilson stated, that with that ambiguity there, the deference to the bankruptcy court and its interpretation of it, and the further deference to the district court and its affirmation of that, holds in this case specifically. And I'd like to bring it back to what the issue is on appeal on this case. It's whether or not the law of the case doctrine was applied correctly in this case. The law of the case doctrine, I submit, is a crucial legal principle that promotes judicial efficiency, consistency, and most importantly, finality in the resolution of.
Well, we know what the law of the case is and the doctrine, but the question is, was this particular issue decided? Bankruptcy court says, yes, it was decided. I'm following the old order.
Correct.
District court says, bankruptcy court correctly applied the law of the case doctrine to this. If there's not an ambiguity, and without prejudice means what every lawyer knows without prejudice means, and it relates to the claims that AKD says that they relate to, then the law of the case doesn't seem to have applied because the difference paid and the amount owed would be different things.
I believe that's what was decided by the court, is that there isn't a difference between the two. I mean, AKD is stating that there's a difference between the two now, but they weren't stating there was a difference at the time. The law of the case submits, and I believe Judge Afric stated that it deals with issues that were specifically dealt with, but also ancillary issues that were done by
Impliedly dealt.
Exactly, implied. And the district court correctly acknowledged that issue because the amount was agreed upon. It was the amount certain that was determined to be paid, come together by the parties, extensive litigation, and specifically in their amended motion, they state all of the work that was done by creditors' counsel and by debtors' counsel to formulate this agreement and to come to that amount certain. So,
Did the bankruptcy court actually resolve the issue? Because if you look at the summary judgment transcript, there's no mention without prejudice, without conditions, and how that interprets anything.
which issue are you specifically referring to?
It was the summary judgment hearing on when the bankruptcy court made their pronouncement of the summary judgment.
So you're saying, did the summary judgment resolve the issue of whether excessive monies were paid?
Right.
No, the
The issue without prejudice was never even mentioned.
They resolved it, Your Honor, by stating the law, by acknowledging the law of the case doctrine and saying that we don't get to that because the amount was determined. The amount was settled at the time that the February 26 order was
So
confirmed.
in your opinion, the issue of the language having without prejudice is meaningless for us to even consider?
It's meaningless not to consider, but it's meaningless as it relates to this issue, the correctness, and this is the issue that they have brought, the correctness of the amount that was paid.
Why did AKD then preserve these claims in its plan and going forward in bankruptcy documents?
I can't explain why they preserved.
Did you receive notice of the plan?
I was not involved in the bankruptcy at that time. I'm not
Do
sure.
you contest that you received notice of the plan?
I don't contest that this time. I'm unaware. I know that the district court noted that notice was not received, or there's no evidence.
Well, the bankruptcy court said that, but if you're not
Bankruptcy
contesting
court.
that notice, I mean, the bankruptcy court may have erred, and does that change things? In other words, if they're preserving it, it makes pretty clear that somewhere, someplace, they got the impression that their claims are still viable.
Well, I don't believe it changes anything, because as the bankruptcy court said, regardless of whether or not they preserve the claims later on in the bankruptcy, it does not make those claims viable or the fact that they even exist.
Well, they may not have merit.
Right, they may have, right, correct, they may have zero merit.
But then what were they doing? Just going through the motions? What were they preserving?
I believe that they thought what they were preserving when they filed their motion or their notice, but that's not what the bankruptcy court said, nor what the district court said. That had already been, that the correctness of the amount had already been settled.
And you don't see an inconsistency or in the refinance order between the amount and with the reserving without prejudice, without conditions?
An inconsistency?
Correct.
I do not see an inconsistency in that what the bankruptcy court said and what the district court affirmed, in that the issue we're dealing with is the correctness of the amount. That's the issue that AKD has brought. And both the bankruptcy court and the district court have said that that issue was resolved. So without prejudice, without conditions to bring other claims would not relate to those claims that have already been resolved. And I believe that's what the law of the case and Judge Afric, through interpretation, is putting
I would
before
say
this
it
court.
this way. If without prejudice means I reserved claims A, B, C, and D. But it turns out that actually claim A was already resolved in the order. Then without prejudice isn't a worthless phrase. It's reserving something. It's just not reserving A.
That's
I
correct.
think that's what you're saying.
That's correct, Your Honor. And then we fall into the issue of res judicata, whereas if it was already decided, then res judicata may move into the situation. And so that is exactly what we're saying, is that the district court was correct in its affirmation of the bankruptcy court, and that this issue, this specific issue of the correctness of the amount, was decided. Unless the court...
At the time of the order, if AKD had contested the order, appealed it, could they have raised this issue at that time? In other words, you overpaid?
They would have had a much better case, Your Honor.
Oh, and could they have appealed it at that time?
They could have appealed it, correct.
I think that's why we're talking about law of the case.
Correct. They could have appealed it. Also, as we state in multiple places, there was no specific reservation of rights. There was no, and in the cases cited by the appellant in the New York case, that case dealt with a creditor specifically reserving his right to come back to challenge for that case. And so, to answer your question, yes. Unless your honors have any more questions for me.
Thank you, counsel.
Thank you, your honors.
Mr. Miller, you have 4 minutes for rebuttal.
Judge, I guess I'd want to point out primarily that the law of the case doctrine starts off with if the same issue was decided, then the law of the case applies. But where it's not specifically decided, where it's not expressly decided, which it was not here, then it can be implicitly decided. But to be implicitly decided requires two things. First, that the matter have been fully briefed before the court.
Was the amount of the payoff not briefed?
It was not briefed. The amount that was owed and why it was not correct, nothing of that was entered in, was a part of it at all. Only an assertion.
Yes, the amount to be paid magazine and the amount owed to magazine are conflated. Your position is those are separate things and the amount to be paid was not the amount owed?
Not exactly, Judge. My position is that the only thing that was in any briefs was the amount that magazine claimed and the assertion by AKD that was not the correct amount. Why it was not correct or what the amount was or how much it should be reduced was never mentioned. Nothing more than the fact that they claimed this amount and we claimed less was owed. That's it. So there was nothing on the merits that the court could have possibly have determined whether AKD's assertion was correct or not. No evidence, no argument, no anything. Only that there was an issue out there, but nothing to be able to resolve it. It was not fully briefed. It was also not a necessary predicate to the final order that authorized this transaction. The court didn't have to determine the correctness of the amount owed in order to approve the transaction. The transaction was free this property up from magazine's claims so that the foreclosure sale would be set off, would be terminated, and AKD could resume its business. Its plan of reorganization called for a continuance of its business that it had been doing at this location for 25 years or so. And that was accomplished by the order because all of the parts that needed to fall into place were satisfied. I guess I would point out that the bankruptcy court relied on the fact, or seemed to rely on the fact, that the commitment letter was incorporated into the judgment, and I think that's a real red herring there too. Magazine wasn't a part of that commitment letter at all. That was strictly an agreement between the substitute lender, the new lender, and Magazine. And the courts incorporated of that accomplished, the effect of that was to say that to further define what transaction I am authorizing AKD to do to get its money, the source of the money that it would use to pay off this amount. And so that commitment letter said, we're committed to make you a loan in this amount. In return for, these are going to be a whole bunch of terms that you're going to have to follow. And so the court said if you do all those things and that's incorporated into the loan documents that were eventually signed, that's authorized. And so the court made that part of the order to specify what needed to be in the final transaction documents that were signed the next morning so that this deal could close and the foreclosure would be averted. Didn't have anything to do with settling the amount that Magazine claimed was owed. It only had to get rid of, it only accomplished what needed to get done so that the foreclosure could be averted with a reservation of rights by the words without prejudice. As far as the ambiguities and the deference to the trial court, this is a matter on summary judgment, and so it's a matter that should be reviewed de novo. Also, since there was a second new judge in bankruptcy court, it was de novo for her too. So she didn't have the benefit of knowing what Judge Magner meant by without prejudice or without condition. The words speak for themselves, and so the ambiguities have to be decided based on those words.
Thank you, counsel. Thank you, counsel. The case is submitted. That concludes our oral arguments.